Good afternoon, sir. Good afternoon, everyone. Today's LinkedIn Live is on the topic of classification of completely knocked down vehicles or goods. It is a common practice for importer of three-wheeler or four-wheeler vehicles, machineries, electronic items to import goods in knocked down condition. That means goods are imported in an unassembled condition for ease and it is then assembled in India. So we would now I would request Vinay sir to address us on the topic which we have today. Sir, over to you.
Good afternoon, everybody. Thank you, Dev. So, as Dev has asked me to clarify on the issue, you see, many a times for the ease of transportation, many of the heavy machineries, or say car, or say three-wheelers like motorcycle, or electronic items like say computer, or any such item, whereby it is likely that if the goods are imported in a finished condition, then in the course of transportation, there is likelihood that the product might get damaged. So in order to ensure that there is no damage in the transportation, and also the cost is less, because if they are imported in as it is condition in a finished article state, then probably the cost will also be higher. So in an unassembled state, which is also called CKD condition, that is completely knockdown condition, the goods are imported and then they are assembled in India. So the question arises whether the rate of tax, whether it is the rate of customs duty or whether the rate of IGST applicable on the import of the goods, whether it will be applicable to that on the finished article. For example, if suppose the car is imported in a knockdown condition, CKD condition, whether the rate applicable to a car will be the rate of taxation of customs or IGST, or whether it will be the rate of taxation applicable to the individual parts. It may be so that the rate of tax on the individual part is high or low, or the rate of tax, if they are made applicable to the article as a whole, then the impact is maybe less or more. But the issue is not whether it is the rate of tax is more or less. The issue is what should be, how the classification should take place, whether it should be the rate of tax applicable to the individual parts or whether the rate of tax applicable to the article as a whole. So here you see there are rules of interpretation of the Customs Tariff Act which is applicable for the purpose of determining the classification of a goods, and there is rule 2 within bracket small a of the general rule of interpretation. I am repeating rule 2 within bracket small a of the general rule of interpretation, which states that even though an article is incomplete or unfinished when it is presented for clearance, if that article has the essential character of a complete article, and or even though the complete or finished article is presented in an unassembled or disassembled form, the classification must be as a complete article. So on perusal of the rule for interpretation, it is evident that even if the article is in a knockdown condition or incomplete or unfinished, when it is presented for clearance, but if they are put together and they will, once they are put together, then they will attain the essential character of the complete article, then even though they are presented for clearance in a unassembled condition, they will be treated as a complete article, and accordingly, the rate of tax applicable to a finished article will apply, and not the rate of tax applicable to the individual parts of that article. Over to you, Dev. Do you have any other question on this aspect?
Sir,
Is
if you
it
could,
clear or do you have any doubt?
sir, if you could enlighten us with any legal precedents in this matter, sir, as to if a goods is imported in a completely knocked down condition. So, is there any legal judgments in this regard as well?
Yes, there is a Supreme Court judgment, and there are many, several judgments, in fact, but I would refer to one such judgment. That is a Supreme Court judgment in the case of Collector of Customs Bangalore versus Mastrio Motors Limited. So, in this particular matter, Maruti Udyog Limited applied for grant of an industrial license for manufacturing of passenger cars and light duty motor vehicles, and they entered into a joint venture agreement with Suzuki Motors, and they imported 24 completely knocked down condition passenger car components, and they filed bill of entry for clearing the goods which were claimed to be components of the motor vehicle. So they wanted to avail the benefit of the vehicle, the rate of tax applicable to the individual components of the motor vehicle, even though they were completing the complete pack of the passenger car. And the adjudicating authority held that the imported components, being the complete card in CKD packs, had the essential character of the finished product, and as such, the consignments were to be treated as motor car and not components. And therefore, accordingly, the assessment order was passed. The matter traveled from CKD to the Supreme Court, because we know that with respect to the issue of classification, as far as the earlier central excise and central service tax regime is concerned, an appeal from the order of the sestate lies directly before the Supreme. So this is also an important principle of law. And here the matter traveled from sestate to the Supreme Court, and Supreme Court, by referring to Rule 2A, it held that what was imported. So Supreme Court held that as per the interpretative rule, even though an article is incomplete or unfinished when it is presented for clearance, if that article has the essential character of complete article, then it will be treated as a complete article. So it was held by the Supreme Court in this case, it is fairly not being denied that the components were imported in CKD packs. Thus, what was imported was completely knocked down cars. The components imported had the essential character of a complete car, even though presented in unassembled form. And it was held that as per the interpretative rule 2A, even though the presented unassembled, they have to be classified as a complete article. Thus, for the purpose of clearance, the components had to be classified as a car, and the tariff heading applicable to the car will apply. So yes, Dev, so this is the judgment which I felt is very relevant to the issue under discussion. So any other question?
Uh, Thank you, sir. Well, sir, my question now is with respect to the current law as well as customs. As in, when I say current law, what I mean is GST and custom. So my next question to you will be, sir, uh, if the custom department disputes uh, a particular rate of tax on which I am clearing my goods, it
Right.
has the jurisdiction to demand for import duty. But can it also demand IGST with respect to such clearance of goods as well?
You see, my understanding on this particular issue is this, that the customs authorities have the jurisdiction only to demand tax with respect to what is the customs duty. And as far as IGST is concerned, it is levied under Integrated Goods and Service Tax Act, that is IGST Act. And as per definition of duty in terms of section 2 subsection 15, duty means duty of customs leviable under the Customs Act. And according to me, the customs duty is levied by drawing its power from entry 83 of the list 1 of the union list. Whereas levy of IGST draws its powers from Article 246 capital A, read with Article 269 capital A. Further, Section 7 subsection 2 of the IGST Act provides that the supply of goods imported into the territory of India shall be deemed as an interstate supply. So as you can see, that the charging section for levy of the IGST Act finds its place in the IGST Act and not in the Customs Act. And further, the rate of tax also is notified under the IGST Act and not under the Customs Act. As far as the valuation is concerned, the valuation also will have to be determined in accordance with the IGST Act. It is only the procedure for collection of IGST, which has been provided under Section 3 of the Customs Tariff Act. The word integrated tax is neither defined under the Customs Act nor under the Customs Tariff Act. And therefore, according to me, all the four canons of taxation, that is the taxable event, the person on whom levy is to be imposed, the rate at which tax is to be levied, and the measures or value to which the rate will be applied, all these four essential elements are there in Section 5, subsection 1 of the IGST Act. And therefore, in my view, the customs officer does not have the power to demand tax with respect to IGST, even though with respect to basic customs duty, the customs officer can issue a so-called notice. But as far as the IGST is concerned, unless and until a customs officer is notified as an officer of GST, it is quite possible that tomorrow a notification is issued under the IGST Act where the officer of custom is also notified as a officer of customs. But that is not the case as on date. As on date, customs officer has not been notified as an officer of GST, and therefore the customs officer cannot demand IGST, or he cannot issue a notice for demand of IGST.
Sir, in this regard, I would like to point out and I want to know what is your take. So recently there was a judgment of Kerala High Court, wherein the Kerala High Court had held that custom officer is empowered to assess IGST exemption on import of goods. So whether this view taken is correct, and if the petitioners in the case, if they file an SLP, to best of my knowledge, they have not. So if they file an SLP, what would be the most probable outcome of that SLP, sir?
You see, according to me, the judgment under of the Kerala High Court is not a good law. It does not deal with all the constitutional aspects of the power to levy IGST and customs, and it also does not discuss whether the officer of customs have been notified as a officer of GST also. So since the judgment does not deal with the relevant constitutional aspects of the levy of IGST and customs as well as the statutory provisions. So according to me, it has not laid down a good law. And recently, you see, this matter was being discussed in the Calcutta High Court, but fortunately for the SSC concerned, the dispute was with respect to the import of electronic motorcycle, which was as a motorcycle, it is taxable at the rate of 5%. But if it is, you see, the taxation is levied on the components respectively, then probably, say, for example, battery is taxable at the rate of 28%, whereas some items of components will be taxable at the rate of 18%. So the department was trying to classify it as a component, but ultimately the good sense prevailed and they dropped the demand. But according to me, the law, as has been held in the case of Kerala High Court, is not a very good law.
Thank you, sir.
So anything else that we can discuss, or shall we close? So shall we close today's session?
Yes, sir. I cannot see any questions, any more questions.
Okay, thank you.